Okay, so let's begin our today's webinar. So today's topic for our webinar is startup registrations and legal compliances for early stage startups. So like what kind of registration is suited, what kind is best for early stage startups. So today we have Mr. Mayank Agarwal. So Mr. Mayank is a legal counsel. He brings a vast experience in field of corporate law, commercial and transaction advisory, and he is also actively involved in advising startups on financial and legal aspects. And he also serves as a business and legal advisors to many startups. We welcome you, Mayank sir. Thank you so much
Thank you.
for agreeing for this opportunity. So without wasting any further minute, over to you, sir.
Thank you, Counsel. Thank you so much, and thank you all for coming so early on a Saturday morning and giving us your time. And many thanks to AICGIM for organizing this particular session. I hope that I was told that this particular topic has been a concern to many of early stage startups who are really thinking of expanding, building on their ideas. So I think by the end of it, and I'll try my level best, that by the end of it, all of you young entrepreneurs who are really looking forward to build onto your ideas, you have some answers to your questions. So Anshul, shall we start with the presentation then?
Yes, sir. Yes, sir. Please, sir.
Okay, I'll just share my screen. Okay, guys. So, so the topic for today's webinar, as it is the registrations, compliances, and exemptions, particularly to the startup. So, before starting with the topic, I thought it will be a little pertinent to start with, the definition of the startup itself. So, basically, what the common notion is. So, every now and day, I hear that whenever there is a, any new business coming up or a new business starting up, people call themselves a startup. But actually, every new business that you start is not a startup. So DPIIT, which is the Department of Promotion of Internal and Internal Trade, they have come up with the exact particular definition of a startup, and that definition has particularly 4 elements. The elements are that it should be a private limited company or a partnership firm or a limited liability partnership. So whatever business you are starting with, it has to be in the form of any of these 3 structures. Then the turnover should be less than 100 CR. Then the tenure during throughout which your startup would be considered as a your company would be considered a startup would be 10 years from the date of incorporation. So let's say your company got incorporated today. So from today till 10 years, you would be considered as a startup. And then the most important factor is that it should work towards innovation, development, improvement, or it should enhance, or it should lay down new products or product service, or as we call it, service as a product or product as a service. So that is way. So this is somewhat a holistic definition of what a startup contains, and it is just not any new business which you start with will be called as a startup. However, there is one small exception carved out here, that if there has been a company working on, and if then there is a spin-off, let's say, or that the company it divides its area of practice, wherein the group company does something else, and then you spin off a part of it, and that becomes the second whole, that company does something else, then that spin-off or the higher part of the company shall become a startup. So it has to be a newly incorporated company in the form of a private limited or LLP, or it can be a registered partnership firm. So this is what a holistic definition of a startup is. So this is it, and then now we can start with the topic. So as you know, getting started, we'll be dealing with the structure, the registration and licenses, compliances, and then there are certain exemptions and benefits which are provided to the startups. So coming straight with the first thing was, which is laying down the structure. So it's very simple to give you a very layman's point of view understanding. that whenever you start with something or whenever you start constructing a building, you need to have a very firm foundation. Similarly, when you are thinking of when you aim of becoming a unicorn, if I may put it that way, if you aim of becoming a unicorn, you need to have a very strong foundation so that the particular startup or the idea that you are building upon, the structure is in a position that they can execute your particular idea. So you need to have a very firm foundation, which is to say that you need to have a strong organizational structure. So when we talk about structuring the company, then you have different options available. Like it can be proprietorship firm, it can be partnership firm, it can be an LLP, private limited company, or a one-person company. I'll give you a brief introduction, or I'll give you a brief synopsis as to what each or one constitutes. So sole proprietorship is pretty standard, which is like you as an individual want to do something. You need to just have a bank account and you need to have a GST number in the name of your firm, and then you can start your business. So that's a pretty basic and the most, I should say, the oldest form of business structuring prevalent in India. Then comes the partnership. So in partnership, what happens really is that there are two partners, a minimum of two partners, sit together, think of doing the business together. So a partnership, you formally get into a partnership deed. It may be registered, it may not be registered, though there are consequences of getting it registered. If it's not registered, obviously there would be certain consequences. And so that's like sole proprietorship only. But in sole proprietorship and partnership both, the liability of the partners is not is unlimited. So personal assets of the partners and the proprietor can be brought into question if the company is running under debt, if the firm is running under debt. However, when it comes to LLPs and private limited company or a one-person company, herein you have the concept of limited liability. So the part in case of an LLP, the designated partners, in case of a one-person company or in case of private limited company, your liability is not unlimited. You are limited by the contribution or the shareholding in the company. So whatever you have to give is limited to that amount of particular shareholding to which you have consented to give. So that is one of the most basic underlying, differentiating factors between sole proprietorship, partnership, and the rest three entities. However, when we come to, if we go few slides, if we go few slides earlier, wherein we talked about the definition of startup, you will see that the DPIIT, when laying down the definition, they only categorize, recognize three forms of structuring while within the definition of startup. So one is a private limited company, the other is a partnership firm, and the third is an LLP. So for the purposes herein, it is for the relevance, of course, we have sort of prepared a comparative analysis between these three entities, which is the LLP, the partnership firm, and a private limited company. So, there's some parameters on which we try to differentiate and bring forward a general understanding. Is like the minimum number of members and partners, like in an LLP.
Sorry, Mayank, sorry to interrupt. Can you go a little slow? Startup participants are asking if you can go a little slow. That might be
Okay. Not a problem.
Sure.
Sorry.
Thank you.
So we'll talk about comparative analysis. So when we say comparative analysis, we have sort of highlighted few factors. Here in on the basis of minimum number of directors or partners that you will need, what are the maximum members and liability. So, and then the existence, whether it's an ongoing firm, it can be ongoing, or it depends upon existence of the partners. So, see, LLP, partnership, and private limited, as when we cross-referred it with the definition itself, these are the recognized, structuring modes of doing a startup, of like launching a startup. But in these three categories, you see, a private limited company has been highlighted in three. The reason being that this is the most preferred form of organizational structure to start your startup business. Because in the long run, when you start your idea gets built upon, you have certain traction happening, and then there are investors coming in, and you want to pitch for investment and go for further funding. Investors usually prefer to go for a private limited company module, because in LLPs and in partnerships, there is a no, and in LLPs, I have not seen investors really be very keen in investing in an LLP sort of a module. So moving forward, if the long-term agenda is that you want to really, raise funding and then, start give a boost to your business in that fashion and take it, in a transactional way ahead, then I think private limited company is the most suited form of, to start your startup business with. Uh, Anshul, hello, Anshul. Hello, Anshul, you there?
Yes, yes, say man.
Acha, Anshul, I was asking you, you said no, the startups had certain queries regarding the structuring. So if you want at this point in time, we can take up questions if they have regarding to the structure.
Sure, sure. Look, if any participants have a question, they can, raise and ask. Mayank, hi,
I have a
Mayank,
question.
yeah, sure, sure. Please ask.
Yeah, so what's the difference between like limited liability and unlimited liability of the partners? Can you please explain about that?
Yeah. So see, when you are working in a partnership module, as when we're dealing with the structure, so there is a sole proprietorship and a partnership. So in a partnership sort of a module, your liability is unlimited. So meaning to say, then when your firm incurs any debt, and there are certain assets in the name of the firm, and if those assets are unable to pay off the liability, then the assets of the partners themselves can be asked to pay off the debt. However, when we talk about a limited liability, as in the case of private limited company or an LLP, so the case herein is that your liability is limited to the extent of the contribution you have made in the company. So let's say in a private limited company, your shareholding is 10% and you have fully paid up, whatever the requisite amount of your shares is, then your liability is only limited to that as a shareholder. You cannot be held liable for any other contribution in the company if the assets of the company will pay off the liability. If not, then there may be a loss. But and similar is the case with an LLP. But in partnership, the personal assets of the partners are called for paying off the debt. So that's the
Yeah,
difference.
I've got a follow-up question to that, if I may ask. So supposedly an LLP actually is registered at my residential address, right? So
Okay.
will that residential address be liable for any bad debts in the future, even though it's just on paper that it's been used as a registration
No,
process?
it's
So,
see, there's a difference. So you using any particular address as a registered address,
uh,
that does not itself cause for no that there's a liability, that any liability is gonna fall on that particular registered address, if I may say.
okay.
So the difference is that if that particular address is in itself is a property, right? So if
Mm-hmm.
that property is owned in the name of the firm or the LLC
Mm-hmm.
particularly, and then
Okay.
if that LLP is not able to pay off a debt, then obviously the assets are going to be sold off to pay off the debt. So
Okay.
in that case, your registered office, your home eventually will be called off. However,
Okay.
if that particular house is in the name of one of the partners, and that
Mm-hmm.
partner has given it on as on rent basis to the LLP
Yes.
itself, then
Yes. Yes.
if that's the case, then obviously it cannot be sold.
Okay, so I mean the best path forward is to actually get this as a rental agreement on that particular property, and then actually have a registration done on that rental agreement as a registered business,
Yeah,
right?
but
To just safeguard any kind of an issue, right? Uh,
I am not able to see. What's your name?
Yeah, hi, my name is Anish, and the reason
Anas.
the reason I'm actually asking is, so I have residence, that's in the name of my dad, okay? So I
Hmm.
need to get the business registered. The alternate option is I can actually get a commercial space and get that registered. But to begin with, if I actually get that registered at my own residential address and through a rental agreement with my father in the name of the business, so my only concern is I just want to make sure that the residential property is actually safeguarded against any bad debt
Uh,
liability or anything like that in the
okay,
future.
I got your concern, Anush. I see there won't be any liability coming on to from that particular angle. But
Okay.
commercially speaking and legally speaking, there should be a commercial property, not a residential property, from wherein you are starting your business.
Okay.
So it
Okay.
has to be a commercial property. So if you are starting it from a residential property, I know that many people do it, of course, because bootstrapping is there, and it's a new
Yes.
business and all. I understand all of those concerns, but then commercially and legally, it's not really viable. Okay,
So,
then
I mean, if I just started to begin with, and then maybe 6 months down the line, I actually converted to a commercial space, would that be any hassle as such in the long term?
see, there is no hassle as such in the long run, but see, this is a very subjective thing, and it's always open to questioning by the authorities if it comes to their knowledge that something you're operating from a residential base, and there may be some cross pushing, and there may be instances wherein you are supposed to give answers to the authorities. However, I would suggest
Okay.
that if feasibility allows, then there are services being provided by registered offices services is being now provided by many co-working spaces. So
Okay.
you can
Okay.
take that for, let's say, for an initial year. So that will act
Okay.
as your registered office address. That's a valid proof. It's a commercial property. All your correspondences can happen from there. You'll not be required to personally, make someone sit at that particular address. So I think that is a more feasible option to
So
start.
all the documentation is going to be actually delivered to that particular address? Is that how it's going to happen?
Yes, all the documentation will be delivered to that particular address. However, they resend it to you on the address that you want it to be.
Okay. Can you give some examples of those virtual offices if you have something in mind at the moment?
I know someone at MyHQ who provides.
Okay.
So MyHQ provides these services. So if you want to get in touch, you can maybe post this session. You can ping me. I'll just share the contact details.
All righty. Sounds great. Thank you so much. Appreciate it. Okay. Sure.
So any more questions? Bidhi has a question.
Yes, I had a question. Hi, man.
Hi.
I was wondering if you start with an LLP because with the private limited, there are a lot of cost, the cost of maintaining an LLP registration and maintaining a private limited company there is a huge difference. And documentation, type of documentation. So you can start, is it possible you can start with an LLP and later on if you find an investor who is willing to put in money into your firm, you could maybe re-register or maybe upgrade your kind of registration?
See, there can be provisioning wherein you can convert your LLP into a private limited company. However, when it comes to costing, I do understand the concern. But from a more practical point of view, there isn't really a significant amount of difference in the compliance cost when we talk about LLP or a private limited company. So if you have any specific concern, I can try to address it. But in terms of compliance cost, there isn't really much difference when we talk about things in the long run. There really isn't much difference.
Sir, but how do you convert, if that is required, how do you convert a partnership into a private limited company? Is there some kind of legal provision? Or
no, he was talking about LLPs, right?
Sorry, go on.
Hello? Yes. I was talking about LLP and converting it to private limited later on.
You're starting with LLP and converting it into a private limited company. If that is the comparison, then I would say start with private limited itself, because from a compliance point of view as well as from a costing perspective, there won't be any very significant amount of difference.
Okay.
Yeah, because I have clients who are not particularly started but carrying on their business in the form of LLC, particularly real estate clients. And then obviously I'm dealing with a lot of startups, so they are all private limited companies. It just give a sense of ease in doing the business, and from an investor point of view, also from registration point of view, also it's quite easy when you talk about private limited company, and the cost of compliances are more or less the same. I don't know where you're getting that it's causing a substantial amount of difference.
Yes, actually, while I'm in fact in off late. And last month I was trying to get my startup registered. So, I mean, this is what I came to know. Somebody put in this understanding into me. So that's what I was just confirmed.
No. It's nothing like that. More or less the compliance is the same. There is some difference, but that's not so significant that you may think of restructuring your company. Because see, in the long run, when you're starting with something, so I'll tell you what the practical difficulties would be. You start with LLP, right? You'll have all your trademark and IPR registered in the name of your LLP. Then post that, when you think of converting it into a private limited company, you'll have to get all of those registrations, licenses, permits, everything converted into the name of the private limited company. And that is an easy process, but that's very tedious in nature. So while you are focusing on your business and expanding your outreach, you can't really be, hold back by such small issues when you're talking about doing business. So that is why I suggest that you, in the initial phase, only start with doing, private limited company.
Okay.
So, if I understand your answer correctly, conversion of a partnership, it cannot be done into a private limited company through any kind of legal process. Is that fair to
No,
understand?
we were talking about LLPs right now.
No, I got that point, but I mean, I'm just asking. Otherwise, partnership
Mhm.
cannot be converted into private limited company. Is that fair to understand?
No, partnerships can also be converted. See, it's just a matter of transferring the assets and liabilities. Okay, when you have a structure in place, in any which case, which you're thinking about transferring it, you'll incorporate a new company, then the assets and the liabilities can get transferred. So that's also possible. It's not that it's not possible. Hello.
But let me just extend my question a bit. Taking over the assets and the liabilities, uh, does that mean the IPR getting transferred to the private limited will be considered as the asset which can be tangible in terms of the registration for DIIPP?
See, the practical issues which I explained to you earlier is the same. When you start your business as a partnership firm and you convert the nature of your entity, or let's say you just incorporate a new company. So let's say you started with a partnership firm itself, not an LLC, and then later on you're getting investments, or you're expanding your outreach and you want to operate in a private limited company sort of a structure. You can always incorporate a new company, and then you can start your business therein and slowly gradually transfer everything to that private limited company. However, the practical difficulties arise when you have to transfer all your IP, all your assets, and all the agreements and contracts also get assigned. So
Sorry,
from that,
I think there was a gap. Can you just repeat what you said, please?
yeah, so I'm saying that the question of convertibility is always there. You can do it, but from a more practical point of view, it becomes very tedious when you have to transfer all your IPs, all your agreements. You have to assign it in the name of a private limited company. So from that point of view, it becomes very tedious, and it consumes a lot of time. So that is why in the most idealistic sort of a situation, you should start with a private limited company, because whatever financial advisor you hire to take care of your filings and accounting, he's gonna charge more or less within the same bracket of whether it's filing the annual return for an LLP. And this is what I'm talking more from an experience point of view and more from a practical point of view as to how I see things happening. So LLP, partnership, private limited company, more or less the pricing is going to be on the same bracket. There won't be substantial amount of difference.
All right, thanks.
Hi, just one follow-up question to that. So you've been mentioning that private limited is more ideal when it comes to startup journey and suited for investors, right? Why is LLP not actually preferred? I'm just kind of curious about it, because most of the startups are going to be bootstrapping, right? So when there's a limited liability as far as the LLP structure goes, why is not that preferred more as compared to private limited company, which definitely has more liability concerns as such for bootstrap companies?
Okay, this has to do nothing with a company, a startup being bootstrap or not. Obviously, you can an investor, if he wants, he can invest in an LLP sort of a structure. In LLP, basically, is the partner's contribution in the capital of the firm. In a private limited company, it's more like the shareholding. So from an investment and from a compliance point of view, it is more easy that you become a silent investor in a company or a shareholder in a company, rather than if you bring any contribution and if you contribute to the capital of the company, you will become a partner directly. And most of the investors, as you may have witnessed and seen, they're not really actively involved in the business of the company. What they are
Yes.
involved in basically funding. So from
Yes.
that point of view, the private limited company, the structure of a private limited company suits their way of modus operandi.
Okay. But you can also, like, maybe not shareholders, but then you can also have an option for like an additional director or something in an LLP, right? Or no, nothing of
So
that sort is possible.
in LLP, you don't have directors. In LLP, you have partners.
Partners, okay. So that investor who's actually bringing funding, he can be a partner in the firm, right? I'm just kind of
They know.
curious, you know.
No. Obviously, they do that, and in a
Right.
private limited company also, they nominate a partner. So whenever
Okay.
you go for a funding, and when you
Mhm.
you sign those transactional documents like the share purchase
Mhm.
agreement or a shareholders agreement, wherein you
Mhm.
contractually agree that there would be a nomination or there would be a representation by the investor in the board of the company. So
Okay.
from that point of view, an investor will definitely have a say because he is investing in a company.
Yes.
So you have
All
some
right. Sounds
representation in the board.
okay. Sounds great. Thank you.
So we can move forward and take questions later on.
Sure. So this was it. Now coming to the next topic, which is which is actually this topic, particularly licenses and registration, is something we can have a separate topic altogether because it's quite vast. It has a lot of to cover. It has a very vast ambit. But there are certain licenses which are very necessary and essential to basically start with your business. And then there are some licenses and registrations which become a need by virtue of the sector you are operating in or the business you are in. So let's start with some of the must-haves. Sorry. Let's start with some of the must-haves that you need to from an understanding point of view and from a more experienced point of view. I feel that these are the few must-haves that we need to ideally have. So first thing first, like you need to have your company or your LLC incorporated, and if it's a partnership firm, it should be registered. Then then the most important thing is the IPR. So whether it's a patentable technology, it's a copyright, it's a trademark, one need to be very thorough and be very careful. And this needs to be done on a proactive, very proactive basis. That you get the patent, copyright, or trademark registered in the name of the structure itself. If in the initial phase you get it, in the name of the individual, like the founder gets it in his own name and then maybe assign it to the company, the practical issue would be that once the funding is coming in, the investor is going to ask you that you kindly assign or transfer the patent or whatever IPR you have in the name of the company, because essentially investor is investing in the company, so he will want everything associated with the company to be in the name of the company. So that's pretty logical from where I'm coming. So these two are the most important things. Then coming to certain basic, very basic, requirements and very basic licenses that we need is GST, of course, the goods and registration tax you need unless and until you are exempted. Then you have a shops and establishment. So shops and establishment is more like a state specific registration. Every state in India has its own shops and establishments act, wherein you need to obtain a license or secure a registration. This I have particularly mentioned because many times when you are opening a bank account or when you are when you're filing your returns, or you're applying for any registration, or you're making any local application with any local authorities, they will always ask you for some government registration. So obviously GST is one of them. So GST becomes one of them, and then shops and establishment can help you for those purposes. And from a more, from a legally speaking, if I would say, the shops and establishments are applicable to every sort of an establishment that is commercial establishment. And if they have any employees, if they have any employees, then that is something which is you need to have. So that is why shops and establishment is something which I have mentioned. Then is the IEC, which is the Import Export Code. So I'll give you a fun fact. So what happens is post, I think, July 2015, there is an amendment which says that all your PAN numbers will initially be your IEC number. So meaning that when you apply for an importer exporter code, your code itself could be the PAN number that you will get. So, but that does not exempt you from making the application. You will have to make an application, get it, formally done, and then you will have it come through. But then eventually it would be a PAN number only. And then the MSME registration, which is the Udyog Aadhaar number. So MSME particularly I've included in the list of must-have because there are many government and government policies, schemes, benefits which you can only avail if you are an MSME. So from that point of view, MSME registration becomes important. And also in times in the current pandemic going on, government launches a lot of MSME centered and focused schemes. So if you want to be a part of those schemes and benefits, then MSME registration is important. So that is why these are the few must-haves that when you are starting with your own business, this is the first set of the first layer of licenses and registration that you need to have. Then coming to DPIIT recognition. So what happens is that we all know that the government of India has launched various schemes for the benefits and exemptions for startups. So one of such thing is that for availing all of those schemes benefits as available to a startup, you need to be a DPIIT recognized startup. So for becoming a DPIIT recognized startup, you need to log on to that website of startupindia.gov.in, and where you can they ask for certain details, and if you fill up those details, it's a pretty simple and standard process. However, if you make the application, if your application gets rejected, that's at the sole discretion of DPIIT and the designated authority, because they alone will judge as to under the parameters that they're going to ask you that whether it will really be a startup or not. So that is very important and crucial, because once you get startup recognition from DPIIT, it really it really adds a sense of a credibility to the organization. The investors are also happy because they are entitled to certain tax benefits post that. So that is why if it's a DPIIT recognized startup things, and if you're applying for GEM, which is the government marketplace for tendering and public procurement orders, then also startup only eligible and recognized startups are allowed. So that is why eventually DPIIT recognition of startup is very important if you're on starting your startup journey. So other than these, the must-haves and the requisite DPIIT startup recognition certificate, there are certain other registration and licenses as well, which are very subjective. Now, the reason I say subjective is because either they will be subjective from the point of view that they're applicable to a particular sector. So let's say that you're operating in a renewable energy sector, then there may be certain certain licenses and permits which will require from the ministry itself. So that is very subjective, and that is very sector specific. So in regards to that, if anyone has any specific queries, then I think we can separately discuss it, because then it will be an ad-length discussion, because we have to check that what in terms of the sector you are operating in, what would be the applicable specific permits, approvals, or licenses or consents required from the government. Then there are certain business specific. Let's say you're opening a restaurant. So now if you're opening a restaurant, then in that particular case, you may need to have let's say a fire NOC, a very basic and layman example. You need to have a fire NOC. So these are not essentially licenses or registrations which are, required to make a business run and manage, but they are really needed. So let's say if you don't have a fire NOC in your building, and then you have an inspection going on, and if you're caught without one, then there may be penalties involved. So those become your business specific licenses and permits. And then it is the labor law, if we call it the blanket licenses and registrations, that becomes a labor law. So under labor law, there are many acts like the Factories Act, Employment Provident Fund Act, ESIC, which is the Employee State Insurance Act. Then we have contract labor. Then this is Sexual Harassment at Workplace Act. So all these acts get triggered only when you pass a certain threshold of employment in the company, and also they are applicable in respect to the operation you are undertaking. So a Factories Act will only be applicable if you're running and managing a factory, in very simple terms. And then when we talk about, EPF, it's required when you have an employment of, when there are more than 20 people, when you're employing more than 20 people. So all these acts are applicable and are very subjective and will depend upon your business, how you are conducting it, and then what is your strength, what is your labor strength, what is your skilled labor, or what is your unskilled labor, and all of those factors. So those become very subjective. However, these are essentially, as I said, if you're operating a factory, you can't do without a factory flag. You can't do without a industrial dispute resolution. So that is why these licenses and registrations also become very important. So this is pretty much it in terms of the registrations and licenses. And once again, I would reiterate that this obtaining the GPIIT startup recognition is very important, because to avail all the exemptions and benefits, this is the first step. Now we can talk about the compliances. So compliances, as in, see, so to give you a broad understanding of compliances. So let's say we got a structure registered. Okay. So when you get your structure registered, it will be either under the Companies Act, or it will be, if it's an LLP, it will be under the LLP Act. Then you have IPRs. So like, which is your intellectual property. So if it's a patent, it is the Patent Act. If it's a Copyright, the Copyright Act. The trademark, it's the Trademark Act. Similarly, GST has its own act, Shop Establishment own act, MSME its own set of guidelines and protocols. So each and every license and registration that you will take will entail or will result in certain amount of compliances under that particular act. Similarly, when we talk about the labor laws, when we talk about the specific labor laws, like the Factories Act has its own set of records and maintenance and information that you have to keep on a daily basis, on a monthly basis, and on an annual basis. EPF has its own. Similarly, you need to have a sexual harassment policy, and you need to file requisite returns also if there are any complaints being raised, if an employee strength of more than 10. So all the compliances arose from all of these applicable licenses and registrations itself. So as I said, if it's structure related, your compliances will fall from Companies Act or LLP or partnership. It's taxation, then obviously income tax is there. You need to pay taxes at the end of the financial year, and then it's the GST. Others is the labor, foreign exchange, and sector specific. So foreign exchange, sector specific, as you know, if you're falling under a particular regulated sector wherein the government lays down the guidelines of policy, so under that also you'll have to furnish your returns. Foreign exchange is something, let's say you have a startup, you started your own, your startup is running, and you receive funding from a foreign party. Like then the foreign party may be a foreign company, it may be a foreign fund, it may be a foreign individual, anyone. And if they are investing in your company in India, then there are the foreign exchange regulations will get triggered. And those foreign exchange regulations, which is essentially FEMA, Foreign Exchange Management Act of India. Under that, what will happen is that you'll have to furnish your returns. In addition to all of the Companies Act, income tax, GST, everything, because foreign exchange is essentially governed by RBI. So from there also, from a compliance point of view, you have to furnish your returns. FLP reports are there, foreign liabilities and foreign liabilities report is there. Then you have FCTRS filing. So when you're transferring shares from a resident company is transferring shares to a non-resident, then also you need to intimate to the concerned authority. So that is there. And then you have let's say FCGPR. So when there are shares transfer happening, the company also needs to report them to the RBI. So that is the FCGPR filing. So all in all, the point which I'm trying to make here is that from a compliance point of view, each and every act or registration that you will take will entail some or the other compliance following from it. Companies Act, like the most basic compliances, if you need to talk about, you need to have four board meetings. You need to have annual general meeting. You need to prepare the minutes of every meeting that you are conducting. You need to have minutes prepared of every meeting. Then there are annual returns which you need to file. Then there is an audit which goes on. Then there is an audit report following that. So all these are compliances, which are there from a compliance point of view. But however, from a practical aspect, if I am to say, as you all are young founders and young entrepreneurs, this is not essentially your, you need to definitely ensure that things are happening and the filings are being made on time. But essentially, this is something that, financial advisor like the CA or your CS, whosoever is taking care of your filing, needs to take care of. So, but obviously, the liability falls onto you because you are the partner, you are the founder, you are the director, or you are the owner of your business. So you have to ensure that this happens. But from a compliance point of view, this is how it really flows. Exemptions and benefits. I think we can take questions if anyone has now on this, but these two particular topics.
Hey, so wanted to know about the DPIIT registration that you were talking about. So there's a specific clause in DPIIT registration that your new business should not be an offshoot from business. So supposedly, like I currently have my own design construction firm that I'm actually tech-based solutions for the design construction industry. Okay, so apply for the DPI registration. I mean, in essence, I'm just working as an individual entity, or about mass consumption, that kind of a thing. So, how does that clause come in?
Clause, wherein there is an exception. The exception is that an entity formed by splitting or reconstruction of existing business does not fall within the ambit of a startup. So let's say you have a family business which is running on, and then you think that, see, this particular division which I need to hive off or spin off, and I want to start, I can push that as a new business in itself, and that won't be considered as a startup. If you want to start up, it has to be a newly incorporated entity.
Okay, so supposedly it's a family business, right? So, and I want to start maybe the design entity with a tech-based solution or something. So I create an XYZ LLP or XYZ private limited company, and I take that design entity tech-based solution to that company. Can that be incorporated? Because I'm kind of registering DPIIT with that new entity's name. So that doesn't fall into the gambit of spinning off or reconstruct.
No, I got your point. I clearly got your point. So has the tech, is the tech, it's a new tech, or was it there with the family business?
No, it's a new tech. It's a new tech altogether.
Then fine. If it's a new integration altogether, it's a new product, or it's a new altogether a new service, as we can say it, then obviously you can incorporate it in a new company, and that does not fall under the offshoot thing.
All right. Sounds great. All right. So just want to make, just have to make sure that it's a new entity altogether, and whatever the business model is and whatever the business is going to be doing, it has to be completely different from the existing business as such, right? Okay.
It's not that it has to be completely different from the existing business. It can be an improvement, and it can be an enhanced service. It can be an enhanced product as well. But then it cannot function, it cannot operate in the name of the whole company, and then you can say, so essentially is that if you have a new product, but then you're operating it in the name of your old company itself, then that won't become a startup.
Got it. Okay, sounds great. Thank you so much.
I have a question regarding this director.
Need to really ask if that intellectual property belonging to the original company gets sold to the new company, and the new company takes it on and applies for DIPP registration.
Sorry, can you repeat your question, please?
I'm asking an extension to what this gentleman has asked. If I have an intellectual property in one company, and I spin it off, that part of the intellectual property, I spin it off to another company and take that as a startup for the registration, and continue to do the business in.
So is the technology new?
The technology is not entirely new, but the framework has been taken from the old company and developed on top of that. The development has been new.
See, that's a subjective thing, I think. Then it depends how DPIIT takes it. However, let's say if it's coming from an old company, it's an old product which you have revised, so that's a business improvement. Does it really have an industrial applicability?
Yeah, I mean, so the key question around here is, that intellectual property has been purchased by the new company. So the asset transfer is there. And on top of that, the new company has built up the layer on top and made as a kind of more formidable product.
Then I think then I think it may be it is very subjective. It depends how the DPIIT takes it. When you'll be filing for DPIIT recognition certificate, this question may not arise in the first place. But in the long run, when scrutiny and inspections will take place, and it will be seen that in a new company with zero valuation, you put in certain amount of capital, you bought an IPR you bought an IPR from another company wherein the valuation escalated. Then you did some R&D of your own, and then you further enhanced the product, and then you're calling that product, or the commercial exploitation of that product as a startup business altogether. Then how DPIIT takes it, I think that's a subjective thing. But at the face of it, calling for a DPIIT recognition certificate, I don't think that would be a problem, because essentially your entity is a new company, and your product, what you, as you're mentioning, is going to be a new product or an improved product.
So just a follow-up question to what he was asking. So supposedly he has an old company and a new company. There was a transfer of tech or IPR. So if that new company doesn't shut down the business, and if the old company doesn't shut down the business, and the new company is already there, so technically both are competing, right? So is there some kind of a conflict of interest that can actually arise if both the companies actually have the same director? One has a startup registration, one is like a traditional company with no startup registration as such. Can there be some kind of a conflict of interest that can actually arise?
So it's not a conflict of interest, but that's more from a point of view of transfer pricing. So actually the thing is that you have an old company wherein there was a certain IP. You transferred that IP to a new altogether new company. The directors remain the same, right? This is what you're saying.
Yes.
The directors remain the same. So if the directors remain the same, firstly the point is that that the transfer of IP should be at a transfer pricing. That is to say that the costing at which the new company is buying this IP from the old company has to be at an arm's length basis. That is, fair market valuation should have happened. It cannot be that you are randomly giving it for free because, let's say, in the old company, your father is the director, in the new company, you are the new director. So this sort of an arrangement will work, because eventually, in the eyes of law, both the companies are two separate entities. Even if it's a holding or a subsidiary company, still there are two separate entities, legally separate entities in the eyes of law. So transactions between two companies have to be in compliance with all the applicable rules and regulations in terms of the Income Tax Act and in terms of the Companies Act. If that transaction is not complying with the laws, then obviously there won't be a conflict of interest, but there would be a breach of law, I would say. So that is something you need to be very careful with.
So, I mean, it was not just that. I mean, I was just thinking on some different lines. So let's say if I actually own a grocery, and long term, I actually develop a platform like Amazon where, multiple sellers can actually put up their products, all right, and the consumer actually has a choice to choose whichever product they want to purchase. I mean, in essence, does that actually become a conflict of interest? Because I have my own business, which actually falls into the realm of a grocery retail. And then I'm developing a platform where, multiple people can actually sell the same product which I'm selling. So does that actually become some kind of a conflict of interest? Do I have to shut down my own grocery chain because I'm actually facilitating that platform? No,
you don't have to. See, you can get, as an individual, you can open multiple businesses. That's not essentially conflict of interest. That's basically you're diversifying. So the conflict of interest does not arise there. However, one thing. Now, practically start this business of your, this aggregator. This aggregator business of yours you start with, let's say, with your co-founding partner. And that co-founding partner, something does not work out between you two. And then that co-founding partner exits the company. And then he starts his own company in the same line of business. Then a conflict may be there, provided that you may have certain rights also in that case, provided you both have contractually agreed to do so. That is a separate topic that I've kept for the last, so we'll deal with all the relevance of contracts and all of this.
All right. Thank you so much. That's really helpful. Okay.
Hey, I have a question regarding the directors. Like, what's the role of directors in private limited? Because I don't because I'm at early stage. We are planning to incorporate a startup. So what's the difference between the founders, co-founders, and the directors? So are they mandatory to have a directors in a private
Yes,
limited?
yes. So see, in a private limited company, there are directors and there are shareholders. Shareholders are essentially the owners of the business who have contributed in the capital of the company. However, directors may or may not have contributed to the capital of the company. So let's say you and your friends or whosoever you're starting your company with start a new company. So obviously you are going to contribute the capital and your friend or your partner is going to contribute the capital. So you essentially become the first subscribers and the shareholders of the company. Now, who's going to take care of the business? You only are going to take care of the business. So you become the director of the company. In the eyes of law, director has a different definition. Shareholders has a different definition altogether. So what will happen is that as a director, you are responsible. As a director, you are responsible for the, for the overall functioning of the company. So that is something that you need to take care of. As a shareholder, your responsibility is not to take care of the operations of the company. So as a director, you take care of the operations of the company. All the day-to-day management of the company is overseen by the directors who sign on behalf of the company. So that's the role and responsibility of a director. If something goes on, liabilities fall onto the directors, not on the shareholders, because you are taking care of the operations of the company. Now, your question was whether there's a difference between co-founder and founder and directors. There's no such difference. Essentially, because of because how the startup ecosystem developed, we just started using these words co-founders and founders. Essentially, these are shareholders and directors.
Okay, it means founder and co-founders can be a directors, but essentially we don't require any directors if we don't want to have. Right?
Yeah. You yourself will become the director. You need to obtain DSC, which is the digital signature, and you need to obtain your DIN number, which is the director identification number.
Okay.
You need to obtain these two things before becoming a director. You procure this, you become a director, a shareholder in the company, and then you work with. Founder is basically the term of we have just coined this term basically to say, I found this business, so I become a founder of this company.
Okay.
That's just it, and that's the end of it. No illegal implications there into say. Legal implications arise, then you become a director and you become a shareholder.
Okay, yeah, got it. Yeah, thank you, Matt.
So I have a question. I want to know that what are the licenses required for OTT platforms, suppose Hotstar, Amazon Prime. So any idea on that?
So the OTT platforms, see, as I said, essentially, what is this happening on the screen? Any idea? Anshul?
Yeah, that's not from my end actually.
Not from my end either, yeah.
You can choose to reshare it.
Yeah, I'll do that. Just a minute.
Yeah, fine.
Yeah, so in terms of OTT platform, let's say, see, the must-haves have to be there. Okay, which is like you need to get your you need to get your company incorporated, your IPR, which essentially if you have a different software altogether or a specific original software as to say, then you'll have to have the copyright and you need to have the trademark registered. GST would be there. MSME you can take. Shops and establishment, if you're owning any place and working, then obviously shops and establishment would also be there. Other than that, in terms of if you say like a Hotstar or a Netflix, all these are broadcasting, they have broadcasting rights as well. So they take all of those rights. So from that point of view, I think you need to take permits before showcasing any content. And for that, I'll have to check and get back to you with respect to what are the particularly specific licenses that you need to take.
Okay, thanks. So, are there any broadcasting license as such required for this?
Content broadcasting permissions you take.
Okay.
You take approvals and you take prior consent.
Okay. Yeah. Okay. Thanks.
So let's move on. Let's start with the exemptions and benefits. So once you have availed, so exemptions and benefits, as I have mentioned earlier, will only, are effective only when you become a DPIIT recognized startup. So if you are a recognized startup only, then you will be able to, avail these exemptions and benefits. So we have essentially classified these into two parts. One is, the tax exemptions, and the other are the general other exemptions or the benefits which are available to you. So in terms of tax exemptions, so if you get a 3 years tax holiday in a block of 7 years, meaning that in term of 7 years from the date of your incorporation, provided your annual turnover is less than 25 CR of those those 3 years, you can take, there would be no income tax that your company will have to pay for 3 years. So that is one. Second is exemption from a long-term capital gains tax. So what essentially is long-term capital gain tax is basically, let's say you have invested in an asset, and that asset may be shares, and that asset may be a real estate property, and then you are selling that property or those shares. Then whatever difference in amount is there, or whatever you have earned, that essentially becomes your capital gain. Now that capital gain is taxable in India. But however, under the startup domain, there are two essential exemptions given. So the first one is that if the capital gain which you have earned, if you invest it in a fund which is a central government recognized fund, then you will not incur any tax on that capital gain. That is the first. Second is that if you are investing the amount of capital gain earned in an eligible startup for a lock-in period of 5 years, then also there will be no taxation on that capital gain. So these are the, long, to explain it broadly, are the long-term capital gain exemptions available. Then there is exemption from angel tax. So what is angel tax? So basically in an early stage, startup company, wherein investor comes on board, he's investing in the company. Essentially, there is no valuation of the company because there hasn't been much revenue generated. There isn't much traction, but still it's on the idea and it's on the business forecasting that the valuations take place, and then when an investor invests. So, but essentially the price of the share at which an investor is investing is more than the market value of the share. So currently, if you incorporate a new company, the market value won't be very significant, right? Because it's a new company with no or less revenue, very nil or very minimal amount of revenue. So obviously the valuation won't be that high, but still you get a decent amount of funding. So essentially the price of the share is, or the market value of the share is more than at what the investor is coming in at. So now this pricing, the tax on this has to be borne up by the recipient, which is the company receiving which is essentially the startup, has to pay tax on this. So under the the government has come up with an exemption that angel tax, all these startups receiving the investment will be exempted from the angel tax purview. That is one. And then exemption from investing capital gains in equity of eligible startups. This is just an extension of what we discussed earlier, that exemption from long-term capital gains tax. So essentially these are the broad tax exemptions which are provided. Then other than the tax exemptions, there are certain other benefits as well. So if you are a recognized startup, your statutory fee in terms of filing for registrations of intellectual property, whether it be copyright, whether it be trademark, or whether it be patent, it gets subsidized. In terms of self-certification is basically, as I said, there may be certain applicable, employee-related or environment-related laws applicable to you. In environment, if you fall under that subject, then only. So for certain labor and employment laws, such as detailed below, self-certification is allowed. That is, no inspection. So see, whenever under a labor law, you apply for a registration or you apply for a license, inspection takes place. You have given the application to the concerned authority, they will come, they will inspect. If no ambiguities are found, then you will get the registration or the certificate. So for startups, this benefit has been given that for 3 years, no inspection will take place. And for the acts which are listed down here, you can self-certify that the director, essentially the director of the company can self-certify on the letter of the company that we are in compliance with all of these 6-9 regulations which are mentioned herein, and that that we are in compliance, and that will be pretty much it. You don't need to formally go and apply for all of these licenses. However, unless if there has been a written complaint filed against you that you are not in compliance with any of these rules and regulations, then obviously inspection will take place. That easy winding up of the company under the fast track mode. So under the Companies Act, winding up of a company is essentially when you're closing down your business. So when you're closing down your business, it's again a very very legal process, very legally driven, and it's very it has its own set of rules, guidelines, and regulations. And essentially, the timeline, if you go under the fast track mode of if there are no liabilities prima facie, then you can go under the fast track mode of winding up of your company, which essentially takes 180 days. However, for startups, that has been reduced to 90. Then fast tracking processing of patent applications, not essentially patent, but yeah, all the IPRs for that matter. If you are a recognized startup, then the processing time taken by the designated authority is comparatively lesser. And then easier procurement norms. So whenever you are procuring it, whenever the government comes up with any e-tender, or whenever the government comes up with public procurement, that is, if the government wants to procure goods, or they want to avail any services for the public itself, or for delivery of any infrastructure project or things like that, then tendering happens. And government e-marketplace is a place where government comes up with all its tenders and the concerned companies can file for it. Whenever you're filing for a government tender, they have a eligibility criteria. They have an RFP there. And all of these eligibility criteria, it tell you whether how much years of experience you need to have, what should be your previous turnover, what sort of projects you have delivered in the past. So what is the earnest money requirement? What is the what is the forfeiture there? So all of these terms would be there and mentioned there. However, if you are a startup, and if you're a recognized startup, registered and verified on the GEM platform, government e-marketplace, then all of these public procurement norms are easy for the startup. That may be tender specific also, that may be in general also, but then yeah, compared to other companies, if you're a startup and if you can work for public procurement or can supply government they can help government with their public procurement orders, then GEM is a decent place wherein to start with your business and to give a good boost. You may think of registering yourself on GEM. So any questions? Then we can start with the other topics.
Like 3 years exemption of tax in block of 7 years. So can we choose those 3 years from 7 years starting from incorporation?
Yeah, you can, but you just have to ensure that your annual turnover does not exceed 25 crore.
Yeah, let's say I incorporated this year, and then if I want to avail this facility like probably after 2 years, so can it be done?
It can be done definitely, but then as I said, it should be for it's for 3 consecutive years, and then the annual turnover should not exceed 25 crore.
Okay, it should be a consecutive 3 years. So like if you start,
it should be.
Okay. Yeah, thank you.
Consecutive 3 years.
Yes, I have to ask something regarding the self-certification thing. So as mentioned that there was no inspection for 3 years. So is it like in those 3 years, if I unintentionally gets indulged in something which is like kind of against these acts, so is it like in that case no action would be taken against me, something like that?
Saranjeev, can you please repeat?
Yeah, sure. So regarding the self-certification thing, like it is mentioned that there is no inspection for 3 years, right? So in case like I get indulged in something which is kind of against the act, right? And I do that unintentionally, not something knowingly. So in that case, like will I be no action would be taken against me, something like that?
Currently, under law, we say that ignorance of law is not a bliss. So even if you do something unintentionally, you will be, the law will eventually catch hold of you. But the point is that the violation of these acts has to be reported. So if there is a verifiable complaint lodged against you for violation of any of these self-certified acts, then only the inspection will take place. However, if you come to know of your whatever you have done and you mitigate it, or the problems are resolved by the time the inspection happens, then I don't foresee a problem, and you turn out to be pretty much lucky. Yes.
Okay, I get that. Thank you.
Mayank,
Mm.
my question is related to the previous section.
Mm.
So, what are the kind of prevailing laws and terms and conditions for allotment of capital for sweat? I mean, sweat capital.
Allotment of.
Allotment of equity for sweat capital. Sweat.
Okay, sweat capital. Okay. So basically, employee stock option or sweat capital, when you want to give your employees such option that you become a part, you'll have a say, you'll be given some equity. Then that essentially flows from the Companies Act itself. So under Companies Act provide under so you need to have an employee stock option in place, employee stock options plans in place. And when you are going, so you're asking the question: are you going to receive any funding in the future, or are it getting contemplated?
No, I want to give equity to one of my employees, and so I'm asking, how can I give stocks to him without any cost?
Okay. So the point is that you need to have an employee stock option plan in place. First thing first, you need to frame that. You need to, as per company policy, you can talk to your CS maybe, or if you want, we can help you with that. You frame your employee stock option plan first. Once you have framed your employee stock option plan, your employees see the point is for one particular employee policy cannot be different, and then for another employee it cannot be different. There has to be a
No,
pretty much
my question is not related to ESOP. My question is related to sweat equity.
Okay, for sweat equity, yes, you can contractually agree. So let's say your employee has as an employment agreement or a consultancy agreement with your company, and let's say he has done and you can attach definitely milestones to it. That this is a milestone, this is a threshold that if you achieve, then only you will become eligible to receiving the sweat option. So that is something that you do contractually. In terms of what filings you need to make, that flows from the Companies Act as to when the shares are getting transferred or how the shares are getting transferred, what is the consideration or what is not the consideration. All of that comes from the Companies Act. But contractually, if you are giving it, then I think I suggest you that contractually in his or her employment agreement, you really mention that no, he is eligible for getting those shares.
And what about the tax implication of sweat equity? I mean, is there a, a, a liability on the person who's getting the shares?
Yeah, whosoever is getting the shares, it's his liability to pay taxes on it. If he's ever gonna if he's get dividends on those shares, first the shares will be allotted to him. That's first. After receiving the shares, if any dividends that's his income, then he will be required to pay his own taxes on those dividends.
No, not in terms of dividend, but as in terms of the capital gain.
Yes, that becomes his responsibility because he is receiving it.
All right, thanks.
So, guys, pretty much all we have covered the topic. We have essentially covered what was what was the topic for today, which is the registrations, compliances and exemptions. So we have tried to give you a general overview as to what are the applicable registrations, licenses, how you can start your business, and all of those things. This is something additional which I thought I'll just share with you guys, and this is pretty much relevant as to because this is more from a practical point of view. And these are the difficulties which we as the consultants, we as lawyers face on daily basis, dealing with startup ecosystem, dealing with other corporate clients as well. That in terms of contract drafting, what eventually happens is when you start a particular business, I do understand the concerns that bootstrapping is there, the finances are a bit scattered and there is no proper cash flow, and then every cost becomes a hassle. So I do understand all of those issues and all of those things, but then you need to think commercially and you need to think of the long-term impact that it may create. So this is something that I have witnessed with all the startups, that we deal with on daily basis. That they really, when they get into a contractual agreement with whatever understanding they have of the agreement or of the transaction, they execute a particular agreement, which in the long run comes and comes and it's basically not does not suit it. So this is just to request you all that whenever you get into a formal agreement, whenever you basically think of getting into an agreement or get a onboarding any agreement, first and foremost, don't use the templates which are readily available on on general searches, because those are pretty standard formats, and every transaction is very different. Everything is very different. Every transaction is very different. You just cannot use a template for another transaction to suit your own transaction. Either you understand each and every clause which is mentioned there in the agreement, and then you probably, like, say, amend it, execute it accordingly. That's the ideal approach to go about it. However, if you don't, then ideally, please really, you know don't just uh, don't just use random templates from anything. Like, I really see that, for employment issues, for consultancy, and even for SP and SHAs and co-founders agreement, I've seen people using the templates that really available on Google. Please don't do that, because these are very basic and standardized sort of formats available, and that really does not suit or help the purpose. And then at the stage of due diligence, when the investor finds out that there are no contracts have been executed, and then during the stage of due diligence, all of those contracts will be presented to the investors, counsels, and they will be reviewing it. There will be many red flags, and those red flags, ultimately, I'm not saying that the transaction will fall off. No, the transaction will happen, but will definitely affect your valuation, because then the investor comes, has an upper hand in terms of negotiation, because your due diligence has many red flags. So that is why, contractually speaking, please don't randomly get into any agreements. Don't just sign anything randomly without putting a thought to it. You really need to think commercially and then execute anything, and think of long-term implications. It also goes with the investors. Even if, let's say, if you're a early stage or you're an ideation stage startup, and you get an investor who really believes in your idea, and then he says that I'm ready to invest, 5 CR, 6 CR, 10 CR, for that matter, and let's execute and sign the agreement. You, just because that he is luring you to give you an amount investment of 10 CR, just don't sign contracts with anything with them, because I've seen that happening. People eventually lose their companies, and there are a lot of consequential and entailing events which happen, which I don't want to get into and quote each and everything right now. But then you need to be very careful with that. So this thing is there, and I think yeah. And guys, think of the future. That is a request I thought I'll end my presentation on. That, in terms of, there are few sectors which are really gaining momentum. India currently is placed at a very strategic position in terms of fetching global FDI, in terms of attracting global investors, global authorities. India is really doing it big, and the government is really taking a lot of initiatives. They are coming up with schemes, they are coming with incentives, they are giving you, there are, in every sector particularly, they have some or the other schemes coming up to essentially support the sector, and a lot of FDI reforms are also happening. So instead of working on something which people have already worked upon, it's something, a short thing, it will work, because eventually in India we are a population of 1.3 billion guys. So you come up with any product, you come up with any service, essentially it will work if it's good, of course. If the quality is maintained, if the pricing is correct, then obviously you have a good chance of capturing the market share. But then think of sectors which are not really tapped off right now. AI, definitely many people are still working, but still there's a lot of scope there. Renewable energy, solar, wind is there. The EV vehicles is something which is really gaining momentum. Delhi has recently passed this EV vehicle policy, and they are contemplating that and they're striving actually hard that by 2024, at least 25% of their vehicles run on EV mechanism. And then health is one of the sectors. Health and fitness, is one of the sectors which is really a thing of the future. So essentially, think of the sectors which are really, take the road less traveled, if I can say that way, so that you'll have something more concrete. You need to have a vision of not say like future of 2 years, but you need to work with a vision of say 5-6 years down the lane. And lastly, see, these were some of the unicorns that that had the vision of say 10 years, if I can say. If they had a vision of 7 to 8 years, and that's why they become unicorns. So if they can, then obviously you can. So I think that's pretty much it from my side, and that's the note I would like to end on. And if there are any other additional questions, I would love to take them.
Yeah, I have one question regarding LLP.
Hmm.
So, minimum 2 partners are required, right? So, in case I don't have a co-founder, so in that case, can I get any of my family members registered with me? So, like just a partner on the papers and not really.
Yeah. Yeah, you can do that. That's not the problem.
Okay, okay. Thank you.
Hmm.
So guys, we can take two or three more questions. And of course, we have also onboarded Mayank sir as our esteemed mentor. So in case of any future queries arise, we can also help you connect with him. So I see no more questions. Okay, thank you so much, Mayank sir, for your precious time, for agreeing for this webinar and facilitating our startups and ecosystem towards the registration compliances webinar. Thank you so much, Mayank sir.
Thank you, Anshul. Thank you. I hope that everyone have some of their issues resolved. And if anyone has any queries, they can just directly write to me, or they can get in touch with you, and then we can resolve their issues. That's absolutely there. That's totally not a problem. And also, in terms of if anyone has any funding requirements, they can also they can get in touch, because we have a network. As I mentioned to you earlier, we have a network of our own VCs and PEs and HNIs. So if some of them are interested in getting funding, or if they are at that particular stage, we can help them and try to talk to our set of investors and try and patch them up with them.
Hello, sir. Am I audible?
Hello. Yes,
Yeah,
yes.
sir.
Sir, I had listed my LLP in March,
Hmm.
so I haven't paid any GST, and we had made
Hmm.
around 6 to 7 transactions.
Hmm.
So what happen if I don't pay the GST? Whether I don't file the ITR?
ITR filing is a different thing, and GST filing is a different thing.
I mean, yeah. What happen if I don't file the GST on monthly basis?
You need to file. Have you? What is the turnover? So if you have undertaken only 6 to 5 transactions, then what is it? What is the total amount of the transactions?
It consists of around 78,000.
28,000. Essentially, you have not triggered the limit. However, if you don't want to file for GST, I think you should voluntarily go. So on the GST platform, if you can voluntarily go, if you just log in there, you'll have this you'll have this option of this cancellation of your GST. You try and do that. Okay, you try and do that on your own. That's pretty simple process. You do that. You state your reason. If any penalty, because since you are saying that the company is already incorporated and transactions have happened, if any penalty has to be paid, that it will mention there itself only. Otherwise, because the amount is not so big, and I don't think so thresholds are even crossed, then if there's no liability, then the cancellation will automatically stand up cancelled.
Sir, the portal you are mentioning, I must have its ID password, but I registered through a CA.
So ask your CA to give you the ID and password. No, that's your ID and password, not CA's ID password.
Okay, sir.
Mayank, so would you be kind enough to share LinkedIn ID?
My LinkedIn ID.
Yeah.
Okay.
If that's feasible for you. If not, that's
no,
okay.
that's feasible. There's nothing there. I think Anshul can share it that with you.
Sure, that'll be helpful. Thank you.
You can take that from Anshul. That's not a problem at all.
All right. Thanks a lot.
Yeah.
Okay, so we'll end this for today. Thank you so much, Mayank sir, once again. Thank you so much, all the participants, for your feasible time
everyone.
on Saturday morning. Thank you, everyone. Thank you so much.
Thank you, everyone. Thank you.